very much, Mr. Powers, and good evening to everyone. I do not generally enjoy the opportunity to be honored. It makes me feel a bit disquieted, but I thought this was an important organization, and I'm honored, Mr. Powers, that your organization has bestowed this honor upon me. I have always had the highest respect for Senator Weinberg, as you know, a former award winner. She has been, to me, a tireless advocate for the public's right to know, and who has consistently expressed a zeal for open and transparent governance. I would respectfully suggest to all of you, she exemplifies what we expect, or at least hope, in our public officials. And I could not be prouder that she is a state senator from Bergen County, and I'm a Republican. I became a judge in 1993 with Judge Mecca, and I'm appreciative that Mr. Powers recognized Judge Mecca. And if I recall correctly, Judge, and you'll correct me if I'm wrong, I think the judge was the Democratic chair when Senator Baer was in office, and I think it was then Assemblywoman Weinberg, and he was a wonderful judge and a terrific county leader. I've always felt it was a great privilege to be a judge. Candidly, I would still be a judge if I didn't have so many children. As the assignment judge in Bergen County, I had the ability to choose the type of cases I would handle. And I purposely chose Oprah and Oprah matters among many other assignments, as I thought then, as I think now, there is very little more important than matters concerning how our government works, or possibly how it does not work. As judges, we don't have the liberty of deciding which laws we agree with. But personally, I was always very comfortable with fulfilling the mandates and the spirit of the Oprah law, that is the Open Public Records Act, that Senator Baer so consistently and diligently worked to have enacted. Mr. Powers asked me to speak about two particular cases. Interestingly, I was reversed on both those cases. I have been proud of a 22-year judicial tenure in which I was reversed less than 10 times. It's somewhat ironic that Senator Weinberg always reminds me that she had me reversed, and that the two cases I've been asked to speak about tonight are two of those matters in which I was reversed. But now that I have retired from the bench, I'm free to say, and I say it with all due and appropriate respect to the appellate division, I remain satisfied my position should have been the preferred one on both matters I will discuss with you tonight. The first case that Mr. Powers asked me to speak about is a case that was called Upper Beck versus the Midland Park Board of Education. I may refer to the gentleman's name, since I can't pronounce it, as the plaintiff, and the defendant just as the board. In this matter, the plaintiff had brought an action against the board to compel it to include documents referenced in the public agenda. The plaintiff was a professor at Seton Hall Law School, was a resident of Midland Park, and his children all attended the Midland Park Public Schools. What happened in Midland Park is that the board would post its agenda electronically, and in that electronically posted agenda, the agenda would reference various attachments, but the attachments were not available to the public. The plaintiff's wife requested these attachments, which interestingly related to one of their children, and overnight field trips for the band in which one of their children was then participating. The Upper Becks were told that those attachments that they saw would only be available after the meeting, and only after they made a written Oprah request. And the board at that time asserted that under the Open Public Meetings Act, they only had to give notice to the public of the time, date, location, and the agenda for the hearing, for the meeting, and that supplemental materials would only be given to the board members and would not be provided to the public. The upper decks understandably took the position that they could not be adequately prepared for the public meeting and to address the questions presented unless they had the attachments and had the opportunity to read those attachments. The board, then by way of its counsel, took the position that under Oprah, what we call deliberative materials were provided only to board members for their consideration, and there was no need to supply it to the public. The plaintiff took the position that the attachments that were provided to the board members electronically could also have simply appended to the publicized agenda without any greater effort imposed upon the board. Respectfully, the board took what I considered to be the considerably strained position that they did not want to, quote, overload. That was the term that the board took. They didn't want to overload the public with information, and they rejected any effort to compromise. The plaintiff then filed his Oprah request. The board denied it and said the agenda was prepared as required by law and the attachments need not be appended. They then filed a complaint and the matter came before me. To me, and I think clearly by way of the stated law, Oprah was meant to ensure that government records are accessible to citizens of New Jersey. In somewhat like manner, the Open Public Meetings Act, that we refer to as OPMA, is to assure the public's right to be present at all meetings of public bodies, unless one of 9 specific exceptions apply. The law as written requires the minutes of these meetings to be disclosed, except for certain particular exceptions, and to be made properly available to the public. The law requires that the minutes that are being released have to be in a form that you are alerted to sufficient facts and information so that you can understand the decisions that your elected officials are making purportedly on your behalf. This, to me, only conforms to common sense, as is my hope and expectation that what we want is our citizens to be able to understand the decisions made by our public officials. I ruled by way of a written decision that without the attachments, the agenda was virtually meaningless to the public, and the failure to include the attachments and simply post an agenda defied the entire purpose of the law. I found that the attachments were an integral part of the agenda, to the understanding of that agenda, and to the issues then presented to the public body. And I did so then believing that my ruling was not only in conformity with the law, but in conformity with the spirit of the law, and in an effort to promote transparency, and possibly, at least to me, of equal significance, to avoid any unnecessary secrecy. I did note, and I thought it was interesting, all the surrounding townships did provide the attachments with their agenda. And then I therefore directed that that which was not privileged or deliberative had to be disclosed. The appellate division, as of course is their prerogative, saw fit to reverse my decision in a published decision by Judge Fuentes. Published decision means that it's precedential. And this is a very active area of dispute in the country right now. A decision which is published is precedential and can be cited. A decision that's not published is not precedential and under our rules cannot be cited. In what I believe, and I say this most respectfully, was a somewhat narrow decision, the appellate division found that the word agenda did not mean attachments, and accordingly there was no obligation to provide the attachments. The appellate court found that I had defined agenda too expansively, and noted, as you heard tonight from Senator Weinberg, that when Oprah was enacted, it was enacted at a time when our information primarily came from newspapers and not from electronic links. The appellate division, therefore, and I think understandably determined, that there need be some caution about a judge's role. That is, it's the judge's role to try to interpret legislation and not to make legislation. And the judge found if the legislature wishes to have a broader definition of agenda, that they were free to do so, noting that the, quote, information technology revolution, end quote, came after Oprah and Oprah. Interestingly, at least for me, the deference to the limited role the judiciary plays is a goal and philosophy with which I wholeheartedly agree. That said, I believe the appellate division was unfortunately and unnecessarily narrow. As we are, though, privileged tonight to have one of our leading legislators, as it relates to open government, and as I believe the senator is working on this project, the problem in this case can easily be resolved by simply amending the definition of agenda in the open law to include all attachments, or provide that attachments need be provided, and thereby I would respectfully suggest better serve our community. So that's commended to your attention, Senator. The second case is far more controversial and is not as easily resolved by our legislators. The case was entitled North Jersey Media Group versus the Township of Lyndhurst, as well as two other municipalities, the Bergen County Police Department and the State Police. Again, as I have now left the bench, I am able to compliment the Record, that is our local newspaper, as a relentless advocate for the people's right to know. Jennifer Borg, the lead counsel for the Record, and the attorneys that work with her, not only have an extensive knowledge of the law, but have learned and realized how it aids in the dissemination of information to the public, and have been very aggressive as litigation advocates for your right to know. I would humbly suggest that Ms. Borg, the Record, and Senator Weinberg have all done an exceptionally capable job in attempting to ensure we have an informed citizenry, at least in my way of thinking, and are all to be commended for their dogged pursuit of information on behalf of the public. Let me provide a little history now that I've been relieved of the restrictions of the judicial office. When I was a young lawyer in this county, I worked for a gentleman who was thought to be the finest criminal defense lawyer. And I would also often have to travel all over the state of New Jersey, representing individuals charged with crimes. And I was struck back in 1976 and 77 and 78 that every time I traveled the New Jersey Turnpike, I saw African Americans pulled over to the side of the road. Generally men, often with out-of-state license plates. And I remember I came back to the office and I said to my partner, I find this so disturbing. The next time I see it, I'm going to pull over and I'm going to represent that person. I'm going to represent him for free. And he said, no, you're not. And that was the end of that talk. Now we'll bring it to 2015. When this matter came before me, there had been well-publicized incidents in Ferguson and Staten Island that were highlighting police interactions with the African-American community. These interactions had become a matter of considerable public interest. And it was against this background that the Record versus Lyndhurst came before me. In this particular case, two African-American men were suspected of attempting to steal a car from a driveway of a woman's home. And in fact, she had asserted that she saw them attempting to enter her car, and she immediately called the police. The two African-American men were alleged to have fled the scene, and there was a high-speed chase throughout Bergen County in about 4 minutes. It ended with the men's car being surrounded by law enforcement and law enforcement officials and their vehicles. It was then alleged that the car in which the two men were occupying quickly moved into reverse towards the police car when shots were fired, which unfortunately ended with one of the African-American men being fatally shot. As I indicated in my decision, the details of that which occurred were what I said, murky. Immediately after the incident, the record requested voluminous records from the municipalities, the Bergen County Police Department, and the state police. I was satisfied, beyond peradventure, that the record was then given a runaround and thought it was important that the matter be addressed. I tried to make clear to everyone then I was not presented with a question concerning the conduct of the police officers. That would be for the police to investigate and or for the grand jury to review. Rather, the only question that was presented to me was the propriety of the denial of the information the record sought. The Attorney General's office had issued an official press release which did have many of the pertinent details of that which occurred. In denying the record sought, the Attorney General's office asserted it was an active criminal investigation and whether law enforcement had used lawful or unlawful levels of force was then being reviewed. As such, the Attorney General resisted the disclosure of the information that was then sought. The record filed a complaint seeking the release of these records. The matter was then adjourned 2 times at the state's request. I thought it was important, and I note to you, the Open Public Records Act envisions a swift and timely disclosure of records, generally no later than 7 business days after the request. Our law also says that these matters are to be handled in what we call a summary or an expedited manner, which basically means there's very little discovery, very little testimony. These matters are decided on the record, and the record's supposed to come to the court, as far as I'm concerned, in a relatively prompt manner. Having had the opportunity to do Oprah matters for over 10 years, it is not an easy act to analyze. There are often multiple questions presented, often in the form that if yes to the first question, then you go to the second, and if yes to that, then you go to the third, and if yes to that, to the fourth, etc., etc. In this case, the Attorney General understandably suggested that there were 2 important exceptions that they urged allowed them and permitted them not to turn over the documents requested. One, they said they were criminal investigative records, which are not required by law to be made, pertaining to a criminal investigation, didn't have to be disclosed. And 2, there is an ongoing investigation, or what we call investigations in progress, in which the law provides there need not be any disclosure if, quote, inimical to the public interest, end quote. In this matter, the incident occurred in September 2014, and the matter came before me in January 2015. That is 3 or 4 months subsequent to the incident. That, to me, in and of itself, was an extensive delay, or at least so I thought. When the Attorney General's office came before me, when they first came before me, they had a capable lawyer. When they next came before me, they had the number 2 person in the Attorney General's office. When they first came before me, they asserted that the release of this information would be inimical to the public interest because the disclosure might corrupt a witness's recollection. They told me the matter was still under investigation, but importantly to me, they refused to tell me, in response to my request, when their investigation would be over. Further, as I indicated to the Attorney General, it was unclear to me whether their position meant that these records were exempt until after indictment, after trial, after appeal, and they would not provide an answer to that inquiry for me. To me, I was satisfied that under any of those scenarios, after indictment, after trial, or after appeal, would be too long after the event, which had an important temporal significance to our community. And as such, I ordered disclosure, believing the matter was of significant public interest and that there was a compelling need for transparency, particularly when the Attorney General was not prepared to tell me when he felt the release would be appropriate. Again, the matter came before the Appellate Division, and again I was reversed by way of a published decision in June 2015, or 9 months post-incident. I think it has something to do with Mr. Powers' ironic sense of humor that he's asked me to speak on these two. The Appellate Court, when they had the matter, held that I should have conducted an ex parte review, an in-camera review of the documents requested. Ex parte means only submitted to me. In-camera means in chambers and only for my eyes. And that I should have reviewed the certification of the state's lead law enforcement officer. Again, I say this respectfully. I'm satisfied that the Appellate Court clearly erred, as I had held in my decision, that there had been no formal application before me to submit anything on an ex parte basis for an in-camera review. Frankly, and again because I'm released of certain chains as I am now retired, the Appellate Court decision suggesting I had an obligation to do that which was not even requested, that is the in-camera review, I am satisfied has absolutely no support in the law. The Appellate Court remanded the matter to my successor to determine what records were subject to disclosure, and my very capable successor, Judge Misdall, has determined that she shall continue that which I started, that is, having the assignment judge review these important matters given their public significance. During the pendency of the matter, the other African-American gentleman who was in the car died. As both suspects were no longer alive, I thought the likelihood of review of this controversial subject was unlikely. I was, though, delighted to read that our Supreme Court has granted leave to appeal and has accepted this case for review to determine whether law enforcement is required to release the records sought pursuant to Oprah or the common law. And it did so on December 15, 2015. A decision on this important matter is likely to come about sometime, hopefully this year. Now, as a footnote to that matter, I'm sure most of us have read about the difficulties in Chicago and law enforcement's relationship with the African American community. Now, I wish to be clear. It is a citizen's obligation to comply with law enforcement directives, whether those directives are correct or not. If there are abuses, they are best handled in another forum and not on our streets. That said, and without having the benefit of reviewing all the police reports in connection with the most recent tragedy in Chicago, it is my understanding that the police officer apparently asserted self-defense, and that the video that was released showed that the victim might have been some 20 to 30 feet away at the time of the fatal shooting. Let me briefly review with you the Chicago matter as I best understand it. On October 20th, 2014, a 17-year-old young man was involved in an incident with officers of the Chicago Police Department, resulting in an officer-involved shooting and the death of the young man, Mr. McDonald. There were video films of the incident from dashboard cameras installed on police vehicles. The matter was investigated by various law enforcement agencies. Illinois has a law that appears strikingly similar to our Oprah legislation. On May 26, 2015, that is almost 7 months after the incident, a resident of Illinois requested the department provide him with a video depicting the incident. The department denied the request on a somewhat similar basis as the Lyndhurst matter, which I just discussed with you. That is, that the investigation was ongoing and that disclosure would interfere with that investigation. Same two reasons provided in the New Jersey matter. The court in Chicago determined that the Chicago Police Department's assertion of prejudice were, quote, conclusory and inadequate, found that the release of the video had not been demonstrated to the court's satisfaction as interfering with the recollection and the testimony of witnesses to the incident, as had been urged in New Jersey, and ordered the video released. We are all now aware of what that release has caused and or effectuated. Again, I am not privy to the records as to what purportedly happened. I am, though, privy that it was the release of the video that shed light on that which occurred. Interestingly, and Mr. Powers, in his ironic sense of humor, did not ask me to speak about a case like that I decided in New Jersey, which parenthetically I was affirmed about. But then, and I did rule that, in fact, the police are to release the videos of what occurred, because I felt then, as I think now, the public is entitled to know that which occurred, at least from a visual perspective, and then to judge for yourselves that which might have occurred. Personally, and obviously not speaking for the judiciary, I applaud the requirements of the utilization of cameras by police officers, and I am compelled to note that it is the omnipresence of cell phone videos which has, at least in large part, totally changed, apparently, the dynamic of law enforcement in this country. Again, I don't wish there to be any misunderstanding. What I say is not intended, nor is it suggested as any criticism of law enforcement, nor is it a comment on its dangers and difficulties. Rather, what I wish to be understood to say is that the best government is an open government. That our system flourishes when the public has access to information and then can properly judge for itself whether we are being well or ill-served by our political leaders. And I would respectfully suggest this applies at the local, the county, the state, and the national level. Many of these issues are not black or white, and there are many valid competing interests at play. To me, though, personally, I prefer to err at all times on the side of openness. Let me conclude my remarks this evening with an acknowledgement of the honor that has been extended to me, but more importantly, to recognize our prior award winners, the record, Mr. Boxer, Senator Weinberg, for their continuing and their relentless efforts to attempt to ensure, and I would suggest to you nobly, that you, our citizenry, are provided with as much information as required so that you, our citizens, can be satisfied our government is working for you and does so in an open, transparent, and appropriate manner. Again, much thanks for this honor, which I humbly accept with most appreciation.